on that point of your Fidelity Fund certificate, I've also read in the provision relating to transformation and BEE certification. So it makes this statement, but we don't know what is actually required. If you can just unpack that the BEE certification for the members.
Yes, certainly. All right. All the Act requires is that a BEE certificate be submitted with your application, and this is only for juristic persons. So, in other words, companies. I see shock on your face.
I've seen 8 minutes. You're not even halfway through it.
Okay, so it's only for juristic persons, in other words, companies, CCs, trusts, and those are the only ones who have to submit a BEE certificate. What the grade or standard of that BEE certificate is really not something that we regulate. That is regulated by the regulators who regulate BEE compliance. So all we want to know that they know about you and they have issued you with that certificate or the affidavit if you are exempted, and that will be sufficient for us to be able to register you.
So, sorry, we're running out of time, so I'm just going to get to certain points. Okay? I'm a managing agent. I don't hold funds in my trust account. It's in the name of the scheme. The money is open in a bank account in the name of the scheme, but I administer that money. Is it protected by the Fidelity Fund?
Okay. No. No, I think we're in agreement with that. Didi, I don't know. Do you want to expand or shall I? Shall I go ahead? All right. You will remember that the protection of the Fidelity Fund is specified in Section 18, and particularly if you look at it, it's clear that the money has to be in possession of the estate agent or the property practitioner or the managing agent, whichever applies, before the cover kicks in. Now, if it's not held in your bank account, it's held in the bank account of the body corporate, then obviously it's not going to fall within the protection of the Fidelity Fund.
Okay, so albeit that I've got full rights to the account, I administer the account, but it's in the name of this community scheme.
Right.
That funds will not receive the protection in terms of the Act.
No, it won't. No, it won't.
I think what's important is that remember the protection is only if the money is in Section 54 account. If it's not in the trust account as prescribed by our Act, then it's not protected.
On that question, on that statement, now I'm a managing agency. Don't like the PPRA, I don't like the PPRA, I'm not registering, I've got a Standard Bank, a current account in my name.
Yeah.
Mm-hmm.
But the schemes pay money into this account.
And it's the scheme's money.
It's the scheme's money.
Yeah.
Then I think we're referring to Section 54.13, which is where the Act specifies that if it's trust monies, and it's in the hands of the property practitioner, its nature doesn't change depending on where the property practitioner puts it. So if he steals it and he puts it in his own account, it remains trust money and it remains covered on the basis that he is a property practitioner. He has received the money which is not his, it is trust money. So he is holding it on behalf of someone else, and he is obliged by the Act to have put it into his trust account. So he is covered by the provision of the Act which says not only money in the trust account, but also if he fails to comply with his duties under Section 54, then that money is also covered.
But I think also what's important is that that person must be covered. They must have a Fidelity Fund.
Yes.
Because if they don't,
is a requirement, obviously.
That
Registration, Fidelity Fund. But now I just use the money and I put it into my current account to go to Mauritius.
No,
That
it doesn't
remains-
lose. It doesn't lose
doesn't
the
lose
nature.
its nature.
Yeah.
Okay. So the one thing, and I think I want to end off with this, and there's so much more, and we've had this discussion that we're going to attend to a webinar, a 3, 4, 5 hour thing, because there's so much questions from the industry. But the one thing that relates to the industry, as managing agents, the one thing that they sell is, I'll take away your responsibility. I'll sort out your life for you. Having said that, there's normally a panel, and it's not an association, but service providers within the ambit of the managing agency.
Right.
Because if you request me, if you phone me and you say, we need to paint the scheme, the managing agent cannot appoint a fly-by-night. Because if they appoint a fly-by-night, it's the managing agent's issue, and 9 out of 10 times the agreement will be cancelled.
That's correct.
But now we're dealing with the limitation clause in terms
Section
of Section
58.
58.
Yes, yes.
And everybody's so scared of that clause to say, well, can I now refer this contractor to the scheme? Now, the question that I want is, in terms of the agreements, and I've seen this, it's standard terms. The managing agent will from time to time have the discretion, or is in fact mandated, to appoint contractors, to appoint service providers, to appoint attorneys. But 58, there's a limitation. We can't encourage
or oblige.
Yeah, so let's unpack 58, whether it's applicable to this industry.
Okay, I think we've had a look at it quite carefully, and we've seen that if you look at the wording of the clause of the section, it seems to be limited to estate agents and perhaps business brokers, because it uses certain specific words which would not apply to managing agents in those circumstances. It talks about a transaction of which you are the effective cause. It talks about the fact that you are acting in respect of appointing a third party who is outside your contractual mandate. And that appears to be the intention of Section 58. So if you look at that, our argument is you as managing agents receive a mandate, and as part of your mandate to appoint persons, to advise, to give information on who would be able to do X, Y, and Z. And as such, we don't believe that you are covered by Section 58 and that those provisions would not apply to you.
The one thing that I've also seen is the word consumer. It doesn't refer to a company, a body corporate. It refers to the word consumer.
Right.
So the consumer is protected. Yeah. Going back to the definitions of the Act refers to the Consumer Protection Act.
That's right.
When you have a look at that, and I've unpacked that, it doesn't seem like a body corporate,
No.
HOA, will be considered as a consumer.
That's quite correct. Well, that is our view. Respectfully, we agree with you.
So, just for everybody's sakes, if they refer a scheme, because you must also understand the politics within a scheme. New trustees, they go through the old budget, they say, somebody read this act, there's a limitation, how did we appoint this contractor? No, through the managing agent, they refer it, okay, you cannot refer that, so let's claim that money back from the contractor, because that's a sanction.
Yeah, no, I think they'd have a difficult time bringing it under this
but
particular
this is my
provision.
Just to put them at ease, they can still make referrals.
Absolutely. I think that what they need to do, and this was the object of this provision, we believe, is that they act with integrity, that's part of the Code of Conduct. They act in the interests of their client, that's part of the Code of Conduct. So any fly-by-night schemes that you've got where your auntie or your uncle is now going to be doing the work and you're going to be getting a kickback, obviously you're going to fall foul of the Code of Conduct. Yes. But this particular provision, this absolute prohibition that you find, is not applicable to us.
It seems, and this is just a statement, it seems as if Section 58 was designed for conveyancers.
No.
The relationship between conveyancer and attorney, master and servant relationship, and conveyancer is the servant of the estate agent. So it seems as if...
Yes.
I think also estate agents, so that they don't force consumers to use
but
certain
this is
services.
the thing. When I read this, it says, I see it in that relationship between an attorney and an estate agent.
Yes.
But because of the wide definition, and this is what everybody's scared of, is do I now form part of the limitation clause? And I don't see it. I don't, look, unpacking this, I don't think you need to fear in recommending, in providing advice pertaining to contractors, because you're as good as your contractor, you're as good as your attorney. And we understand this, so don't fear. You can still recommend and work with your panel.